Hello, family. Welcome back to another episode of Speaking Legally, where the legal meets the cultural. We're glad that you are here to join us again on this first Wednesday in the month of August. How did we get here already? It is a month of new beginnings, and we continue to always keep everybody in mind. It's been a rough year. We know that between the coronavirus, the racial unrest, the financial insecurity, a lot of people are concerned and worried about a variety of things. So we hope that this show gives you the insight on the legal end as it meets with our cultural, and we appreciate that you've been sharing the broadcast, you've been telling people about it, and that you've been gathering some great content and information from our co-hosts who are experts in the area of criminal law, civil, and immigration. So we're missing one today. It's because he is up in the air in the friendly skies on his way back to New York. But of course, Ed Pichardo, Esquire, sends his regards to each and every one of you. And by the grace of God, he'll be with us again next week. But I'm going to turn it over to our other co-host, Royce Russell, Esquire, so he can greet us today.
Well, welcome everybody. I'm glad that you're back. Today we want to make sure that history doesn't slip away and make sure that we keep our eyes on the media, even though there's so many things that we need to focus on. And so we're going to do a quick look back and a look forward and a look present at what is happening with the officers pertaining to the George Floyd situation and the officers pertaining to Breonna Taylor situation. And we'll talk about a little bit of the differences within there. And we'll have our guest of the evening, from the LA Lakers. We'll see what he has to say about the situation. He flew in just for our show. So we can put him on spotlight. I was gracious enough to let him have a little airtime. So we'll see what happens with that. All right. So,
oh my goodness. You all know Mr. Russell. And hey, Deborah. Hey, Richard. Thank you for tuning in and joining us.
And to my partner, Ed in the skies, I hope you land safely, and we'll get on this immediately. All right.
Absolutely. And Robert, thank you as well for joining in. We appreciate you all being here and being a part of the show. So as Mr. Russell alluded to, we did get access to a special guest, but this special guest is talking about something that unfortunately we have been dealing with for months. So this is an article that just came out on August 4th, and there's a live interview with Mr. Russell's friend in his head.
Quite a while now. Never afraid to speak about, things that I was knowledgeable about, that I had insight on, and I was, up to speed on, and with the Trayvon Martin case that obviously years ago, with that situation, I spoke about that situation, with the George Floyd incident that happened not too long ago. That's a horrible incident, and also obviously the Breonna Taylor situation. It's unfortunate that it was fortunate that we had the George Floyd video to see it. I mean, is that what we need to see a video of Breonna being killed for people to
Stop right there.
Yep, that's where we're going to pause. He'll be talking with us throughout the show, but do we have to have a video?
The answer to that question is yes. I mean, reality and history has shown actions speak louder than words. Videos speak louder than what he or she can say. And when you live in a world where we're constantly having to prove ourselves, because that's what he speaks about, also about being 2 times better, 3 times better, we constantly have to prove ourselves, letting our other folks know that it's hard for us to get a cab, how we have to strategize, how we leave our house, how we know the feeling of what prejudice and racist feels like, and when someone is not stopping you for or questioning you, something that is sincere, but it has some antennas of prejudice and racism intertwined, the answer is yes to that. And there's no 2 ways about it. We always need more. So when we talk about in cardiac arrest, we talked about no longer being a victim, or we talk about think calm. One of the M's in both of that, not being a victim, and M is to make it happen, right? And so how do you make it happen? You make it happen by, having a video, by intervening. And when we talk about the M in think calm, we talk about making a call, right? And these are the things that we need to do to protect ourselves when we're dealing with abusive and excessive force, and we're dealing with law enforcement, and we're dealing with situations where we feel that we're being compromised, whether you're being compromised in a retail store, someone accusing you of stealing, and you haven't, and you know that you're so far from that. You want to see what the retailer has on tape, because that will make or break your case. But I just want to, I'll put a pin in that, and want to once again re-engage our audience in what has been happening since the time of the George Floyd incident, in reference to the police officers and in reference to the police officers over in Louisville. As it stands now with George Floyd, we know that at least three officers were arrested, and I'll read their names and do the best I can with the pronunciation of them. It's Thao, Thao, Thomas Lane, and J. Alexander Kung, Kung. I think that's the correct pronunciation. As of late, Thao, Thao, he was the most recent officer to be released from jail on a $750,000 bond. And that happened as of July 5th. So what I'm bringing this up so we can always remember that as time is going on and we're focusing on President 45, or we're focusing on our daily lives, and we're not getting the news that we need, hint, 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 news that should be created for people of color so we can keep abreast of what's going on. Hint, 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 we should be aggressive in finding news that concern us and that's about us. We realize that one of the other defendants, because that's what we're going to call him, a defendant, has now been released from jail. And his bail is consistent with the bail as to the other two defendants, even though one of the officers was more active than the other, right? And so they all have the same amount of bail, which is $750,000, which allows them to be home with their family. There's no home confinement. There's any other restrictions, but for the fact they have to, can't leave the country, but they can travel within the state that they're in, and they're out in the public. So although they are fired, they're not behind bars as they wait for their day in court. And so when we talk about their day in court, one of the things that we've heard quite quickly is all the charges that could happen and what they may be charged with. Well, the reality is that as it stands now, there's basically three charges that I am aware of that they have been charged with. And so I will read those. They've been charged with second-degree unintentional murder. There's been a charge of third-degree murder. There's been a charge of second-degree manslaughter. And there's been a charge of aiding and abetting in the second degree, all right, in a manslaughter. Now, I would tell you it's not enough just to say what it is. Let's go into the definition of each one of those so we can be fully educated, because I know Dr. Grant is like, wait a minute, let's make sure that everybody knows what we're talking about. So I'm going to meet her to the finish line. So we talk about aiding and abetting. That's what we're talking. We're talking about crimes, aiding and abetting, manslaughter in the second degree, and that applies to the latest officer, Tao, who was most recently released on a $750,000 bond. And so what is the definition of aiding and abetting? There's no secret. I look it up. I knew it as a prosecutor. I know it as a defense counsel. But in each state, there may be little nuances. So no fear, I'm here. Let's go to the Minnesota statute. It says a person is criminally liable for a crime committed by another if the person intentionally aids, advises, hires, counsel, conspires with, or otherwise procures the other to commit the crime. So how do we apply that to the fact scenario here? Tao was shown in the video standing and keeping people away from the bad actor Chauvin. I think his name, Chauvin, Derek Chauvin, or Chauvin. Shaven, who is the bad actor. So Tao is standing there protecting people from intervening. And if you look at the video, to a certain degree, he's like blocking some of the video. Now, Shaven So we know is still in custody and he's on $1 million bond. So he's not going anywhere. But we're talking about the others that participated in it. So that is aiding and abetting. I'll repeat it again. A person intentionally aids, advises, hires, counsel, conspires with, otherwise procures the other to commit a crime. So clearly there's an intentional aiding and advising in that he's protecting the crowd, or at least protecting his fellow officer from the crowd, which gives him room to continue the bad conduct. And so that is one of the charges. So let's talk about the other charges, and let's get into the definitions, because I think it's important, because once again, we don't need no sidewalk attorneys. We want to know what we're talking about, right? One of your favorite terms, right, Dr. Grant?
Absolutely.
Okay. So we're talking the charges of second-degree unintentional murder. I've never heard that before. In New York statutes in New Jersey, there's no such thing as a second-degree unintentional murder.
What does that mean? Unintentional.
So you say, what does that mean? That's what I said. I scratched my head when I heard it, right? So the definition is killing a human intentionally, but without the premeditation. So I put in parentheses, premeditation, not thinking about or preparing beforehand. Now, although the title sounds a little unorthodox, I never heard of second-degree unintentional murder. To a degree, when you look at what took place, one can argue that when Officer Shaven left this house, maybe he did not have the premeditation, thinking about and preparing for the act of killing someone. So therefore, it was unintentional. However, there's a certain side that says, of my brain, that says, there is moments in time while his knee was on the neck, the unintentional became intentional. And that's where we get some of the other charges. So what other charges are we talking about? We have murder in the third degree. So what does that mean? It says without intent to affect the death of any person. Now, let's be clear. A lot of the language within the criminal statute really goes to intent or no intent. And so far we've heard two, and I've read two statutes that talk about not having intent. So murder in the third degree, without intent to affect the death of any person, causes the death of another person by perpetrating the act imminently dangerous to others and evincing depraved mind. Now, you may say to yourself, Royce, you just said that during the seconds while he was on the ground, unintentional could have become intentional. And I do stand by that. But now let me put my prosecutor hat on. Hold on 1 second. Let me put my prosecutor hat on.
Oh, boy.
So now I have my prosecutor hat on. Now, as the prosecutor, I have to think about, what can I prove? What might be the easiest? What might be the most appropriate? Yes, and it's tinted to the side because I'm a Bronx prosecutor, right? It can't be straight. What can I prove? What is the best case to present to the court? So when you look at murder in the third degree, you look at without intent. That means that I do not have to convince a jury what was the mental state of Shaven at the time that he killed, and I will say killed, George Floyd. I can talk about it, that as I have, as the minutes went on, the 8 minutes and 46 seconds, when does something that was unintentional become intentional? I can talk about that. And here we go. We got Mr. Russell chiming in, saying, how long does it take before unintentional becomes intentional? That is a question of fact. There's nothing in the law that'll give you that timeline. And so what you have to do is that you have to take the facts and you have to apply it to your common sense and human life experiences. And so once again, could something that starts out on minute 1 be unintentional and minute 8 be very intentional? Yes. But do I want to put all my eggs in that basket to try to convince a jury of that? The answer might be no. So you look at third degree murder without intent to affect the death of any person. You didn't intend it, but you still caused the death of that person. And that is important because you're holding a person accountable for the end result. But let's go even further. Let's talk about second-degree manslaughter. Now, this is where we get a little bit on shaky grounds here, what I call noodle legs. You know what I mean? Your legs is not as steady. You know, this is what I call a fake out. If anybody play basketball, somebody go to the left and go to the right, and you see a guy fall down because they don't know which way he's going, this is what I call the noodle charge. Second-degree manslaughter. It says knowingly take a risk that results in the death of a person. Sounds pretty appropriate. Knowingly, consciously taking a risk that results in the death of a person. The problem with that, and the reason why I say it's shaky grounds, because manslaughter is a lesser charge than murder. Don't like. The word knowingly gets back to the intent in one's head. Do you know that if you keep your knee on someone's neck, you will cause them death? Some would say yes. I would say yes. There are some people that may say no, or consciously having that thought during the time of your act. So these are some of the charges that these officers face. So we know that they're fired. We know that they're out on bail, $750,000 for 3 of the officers, and $1 million bond where Shaven is still incarcerated. And so he's still in jail. And so what do we have to look forward to? We talked about the charges. There may be more. There may be some manipulation. But I think as a culture, what we really need to look at is this thing called, and I mentioned it quickly early on, but I'm going to go one step further and mention it again, is what we call change of venue. Mr. Russell, why are we talking about change of venue? I heard you. Let me respond. Because we've had protests, and because we had the civil unrest, and because this is a nationwide viewed by everyone, and international wide viewed by everyone, we cannot fool ourselves to think that the defense counsels, and I've heard some of their interviews on TV, have already hinted at trying to get a change of venue. And so what does a change of venue mean? It's exactly what we say. Change the venue. So at first we thought the Lakers was playing at home, and now we find out they're playing away. They changed the venue. We take that from the basketball court and we use that language and we put it in the courtroom. Defense counsels file a motion to change the venue. They file a motion to say, Judge, we need to get out of here. We need to get out of Dodge. We can't have a case here, this type of case, and my clients receive a fair trial in this environment. So we need to leave and go to another environment. Where have we seen this? We've seen this in New York before. Amadou Diallo, case in the Bronx. We had civil unrest. We had protests. We had the truth tellers coming out and speaking the truth. And what happened? Defense counsel put a motion in for a change of venue. Tried the case up in Albany. Not that many marches up in Albany. Not that many black folks up in Albany. Different jury up in Albany. Therefore, different result than what you would get in the boogie down Bronx. Fast forward, George Floyd. Same thing. Nationwide outcry. We're going to put a motion in for change of venue. Actually, without my prosecutor hat on, it would be malpractice if defense counsels didn't do that. They're fighting for their client. They have to do what they have to do. And so when is this motion filed? It could be filed minutes, seconds, hours before the juries are sworn in. Usually it is filed during pretrial motions. That's motions that happen before the court, legal issues, what could come out at trial, what can't come out at trial, you know, whether or not the officer has a criminal history or has a history of being abusive. Can we bring that out at trial, or are we prevented from bringing that out at trial? And that's why it's important that we vote as to who are judges. If judges are appointed, there's nothing that we can do about it except for a vote for the right mayor that hopefully has the same mindset as you, that would pick judges that about justice, or elect judges that you know about their background. So a case like this goes before that judge. That's a judge that you voted for, and you may have confidence in that judge and what that judge may or may not decide. So the motion for a change of venue can happen just before a jury is sworn in, usually happens during pretrial motions where we talk about legal issues before the trial starts. But now let me go a step further and explain to you in Minnesota how that works, because I know how it works in New York, but this is how it works in Minnesota. So there are grounds for which you could bring a motion to change venue. And when I was 25, I could remember everything, but now at the age of 25 plus, I'm gonna go to the board. And the board says, here are the grounds. If the court is satisfied that a fair and an impartial trial cannot be had in the county it is pending, they can entertain a change of venue. Now, what are the reasons for change of venue? One, can't have a fair trial. Very obvious. Two, for the convenience of parties and witnesses. That wouldn't apply here, because why not have it in Minnesota? Why not have it in the county where the incident took place? All the witnesses and all the parties are here, so that wouldn't be a ground. In the interest of justice, we need to put a plug in that, because that can go both ways.
Right.
So back to that. And the last is, as provided by Rule 2502, governing prejudicial publicity. Can you imagine that? That doesn't even, so that means there's a special rule. And now this was way before George Floyd even happened. Somebody was doing some forward thinking that if you have negative publicity, Rule 2502 in Minnesota rules, and then you have to go by that. So if I'm defense counsel, what would I do? I would definitely file under Section 1 of 25, Section Rule 2403. I would definitely do that, because I would say, hey, we can't get a fair trial. Then the question becomes, why do you think that, Mr. Russell? Well, I go 2 because of the negative publicity. And then I say 3 in the interest of justice, because the negative publicity has done so much damage to my client that in the interest of justice, I need to have a trial somewhere else. Isn't that amazing?
Wow.
It's a mouthful.
It's a mouthful. I'm sitting here listening to it like, this is why we do this show, where the legal meets the cultural. So we really understand what's going on. We just don't get sound bites in the media of what's happening. And there are a lot of questions in the feed. And Richard, I know that you had asked about another issue or event that happened with the family being handcuffed. So we'll try to get to that at the end of the show or for next week's show. But there are a couple of questions. Deborah says, is this why when someone murders another person, it's difficult for them to actually be prosecuted for the crime because of these technicalities? I think that's a great question. And then there's another one where Isabel is asking, how do you feel about disbanding the police department? So this brings up a lot of emotions for us as a community. When we hear these things, we hear the statutes. You said long before George Floyd, that piece was put because somebody was thinking. There have been other cases that dealt with negative publicity. So somebody was doing their work on the council, city council. That's why local elections are important. Who are you putting in these positions? While this particular person is occupying public housing on 1600 Pennsylvania, there have been a lot of appointments and positions that people are not paying attention to that create policy and that lead to what we're understanding today in our conversation as Mr. Russell breaks down the law. Please take it over.
Let me say one thing. One, I do think we need police, right? I don't think we can live in a world without police. There's going to be some enforcement somewhere. The problem that I see is all about implementation. Implementation is where, the instability and the racism, the classism, the quotas, the prejudice, poor discretion comes into play. So need police. Implementation is off the chain in all other directions and always to the demise and disadvantage of those of color. When I hear Deborah Johnson's statement, you're right. It is difficult. There are a lot of technicalities, but what works against someone today works for someone else in the future. And we know there's far too many times that those There are people out there that are wrongfully convicted. And it's these technicalities that people have looked over that allow other individuals later on in life to look at them and say, hey, look, there's been a wrong. You forgot these technicalities, and therefore someone has been vindicated. And we all know that if a loved one is on trial, we want to make sure all the technicalities, I's are dotted and T's are crossed. But I agree with what she's saying. These technicalities are not being used to the advantage of people of color, but to the disadvantage. And so her and I, we're on the same team all the way, all day on that. But I mentioned the governing prejudicial publicity, and I stopped there, but it goes on, because what does that mean? What is the definition of that? I said it, but what does it mean? And so I want to define it. So here's the definition: methods in which you can prove that there's prejudicial publicity which will fortify, support your motion to change venue. Now, I'm not saying anything that no one else is dug up. Now, if you think that on this show right here, I'm saying something that, oh my God, Mr. Russell, why are you saying this? Because now the defense counsel from Minnesota is looking at the show, and now they're going to come up with this. Come on now. Come on. They know it. We just need to know it. So when we have conversations about it, we could be ahead of the curve, not behind the curve, all right? All right, or not part of the curve. So let's go on. Methods of proof. One, here go method of proof. Group number one is through testimony. So you can have people that come in from the community and testify that, oh, because of the negative publicity, I would think that this person is guilty. We know where those people will come from in this particular case. Mm-hmm. We know how easy they'll be able to get those people to come forward in this particular case. So in that group, you could do it by testimony. So let's say the neighbors don't want to show up because they might be vilified. You could do it by affidavit. So what's an affidavit? An affidavit is a document that can be drafted that says, I, Royce Russell, reside at XXX, which they could redact so nobody will know where you reside at. I have lived in this community for 29 years. I've watched the news. I've watched people protest. I've watched ABCD happen since the George Floyd incident. And I believe that this person will not get a fair trial here. And I'm part of the community. That's what you get, affidavit. And they sign under the penalty of perjury. That means if you sign in your line, you could spend 1 year in jail. So you have to show identification when you sign. Or guess what? You could just get written statements. You could just get people just to write statements. I think Officer Shaven would not have a fair trial. I think Officer Thal would not have a fair trial. I think Officer Lane would not have a fair trial. You can just get statements, and you can submit that as well. You can also submit what they call qualified public opinion. Now, if I remember in Amadou Diallo, that's what they used. What defense counsel did was that they hired a consulting firm, and they went out there and they did surveys, and they got the public opinion as to whether or not a fair trial could be had. And then they came back with the numbers. Almost what sports teams do now. They calculate the numbers to see what's the better shot. So they shoot more 3-pointers than 2-pointers. Or they'll, in football, they go for a guy who's left-handed versus a guy who's right-handed. So they're using these numbers to come up with operation to say that, yes, a trial cannot be had here because public opinion is so negative, right? So then the third is what they call other probative value material. Now, guess what? There's no fucking definition for probative value. Excuse my language. What is probative value? What's important to me may not be important to you. But it is written vague as that probative value. So that means what a judge may think is important. Now, I would tell you that if a fifth grader wrote me a letter, I might find that more important than a 55-year-old wrote a letter, because fifth graders are more innocent. They haven't seen the world from a perspective that someone more experienced have seen it. And if they write a letter, and if it's not coached and it's sincere, that might hold a little bit more weight than someone who's been experienced and who has all the ills of what life can bring. So we have to be careful when we talk about probative value. So those are the standards
Wow.
to deal with governing prejudice publicity, prejudice media publicity in reference to a judge moving forward with hearing this type of motion.
Now,
Now, I'll let you interject, but there is one more part, what the standard is. So go ahead, Dr. Grant, and then I'll continue.
We're about to go and transition from George Floyd into the Breonna Taylor case and listen
Without a question
from LeBron, but just hearing all of this, and this is with the fact that they got arrested, even though they're out on bail. Like, we moved this far along the journey, and we see how many loopholes and how many ways in which the defense attorneys can try to spin on behalf of their client to get them off. And Breonna Taylor, we can't even get them arrested to get to the first point. So it's just, as I'm listening, and I'm sure the audience is listening, and you're understanding all the layers to this one case, we have a long road ahead of us. And that's why we can't stop keeping the pressure going on having accountability for both these cases. And unfortunately, the additional cases that have come on board since both of these incidents happened. But continue with the wrapping up before we go into.
So let me just say something. And you used some language that was offensive to me. And I know you don't know this, but you hurt my feelings. You really did.
Now, you know I wouldn't do that.
I know you wouldn't do it intentionally. So it's one of those unintentional acts, if you know what I'm saying, right? So what did you say that hurt my feelings?
What?
You said defense counsel and loopholes.
Oh.
Defense counsel is not trying to find any loopholes. I'm a defense counsel. I got to stick up for my brethren. We're not trying to find any loopholes. In actuality, we're just making sure that the I's are dotted and the T's are crossed, because should it be your cousin, your brother, your uncle, your friend, you wouldn't see it as a loophole. You would see it as Mr. Russell's the best attorney on the earth, because he saw that my son, my brother, my uncle was not, or my daughter was not being protected, and he voiced it. So I don't want to shade. I do have a shirt that says shade, but no shade. And we'll wear that next week, because
forgive me. I'm not coming for all the scouts. It wasn't intentional. But
we don't want to give out your address. We don't want to give out your address. So you have to give. But once again, culturally, in a little bit of levity to the matter, I understand what you're saying, right? This is what's going on in this particular case. You know, we're looking at loopholes. We're looking at things that is going to frustrate the situation, right? And frustrate justice, let's just say. So the standards for granting the motion, and then we'll move right into Breonna Taylor. So the standard, it must be granted. The court must grant this. Must, not may, not shall, not can, but must. That means you got to do this. Must be granted whenever potential prejudice materials create the reasonable likelihood that a fair trial cannot be had. I want to read that again. And I'm not even going to talk about it. I'm just going to read it, because I think everybody understands this. The standard for the judge, he must evaluate the following. The motion must be granted whenever, potentially, it doesn't have to be actual, it's potential, prejudice materials, what we talked about, statements, affidavits, censuses, consulting firms, creates the reasonable, what is reasonable to me may not be reasonable to you, so let's watch out for words, reasonable likelihood that a fair trial cannot be had. And I put in parentheses, actual prejudice need not be shown. That's the last sentence of the statute. Actual prejudice need not be shown. So that means it doesn't have to be factual. It doesn't have to be actual. It could just be the reasonable or likelihood, the likelihood that you might get hit by a car when you cross in between the green and not the red. It's a likelihood, but it's not factual. It doesn't actually happen all the time. There's a likelihood. And that is what the judge has to use as the measuring stick. And we can't even get that far with Breonna Taylor. So
yeah, well, Richard is coming to your defense.
there you go. That's right. So now let's go back to
LeBron, our other co-host for today, and see what else he has to say as we move into talking about what's still outstanding with the Breonna Taylor case, which to me, it's amazing that we are still here. Like, I don't even.
Yes. I don't even believe they was at the right place, right? Council wasn't even at the right place. They just knocked down the wrong door and started doing what they did at that point in time, and that's just shooting away, and that's just not okay. So I never, like I said, I never shied away from being who I am and speak about things that not only affects me, that hit home for me, but also affect my community and affect Black people. Because we've been going through it a lot. I've seen a video today of a Black man inside like a Walmart or a Target, wherever, trying to buy a bike for his son. And the cops was called on. He had a receipt and everything. And the cops was called on, and they arrested him inside the store and took him outside. And it's just heartbreaking, man. You guys don't understand unless you're a person of color. You guys don't understand. I understand that you might feel for it, but you can never really truly understand what it is to be Black in America. So, but once again, that's what it's about. A lot of people kind of use this analogy talking about Black Lives Matter as a movement. It's not a movement. When you Black, it's not a movement. It's a lifestyle. we sit here and say it's a movement, and okay, how long is this movement gonna last? Don't stop the movement. This is a walk of life. When you wake up and you Black, that is what it is. It shouldn't be a movement. It should be a lifestyle. This is who we are, and we understand that. And we know that for one step that someone else might have to take, or for 1 yard someone else may have to take, and we know we got to take 5 more steps, and we know we got to take 10 more yards to get to the end zone. I mean, we understand that. We know that. So, but also what makes us, it's strong, makes us it's powerful, makes us so unique and unified, is that we had so much hardships in our life, either from personal experiences or loved ones, or reading history, or seeing videos, Rodney King, or just being a part of just the communities that you're in, where you just racially profiled from the time you come out of the womb. So, it's not a movement. I don't like the word movement, because unfortunately in America and society, there ain't been no damn movement for us. There ain't been no movement.
And so LeBron has preached, and he has said his words, and I thank you for being on our show. We really do appreciate you spending some time coming out the bubble and coming to say a couple of words to us. And I hope to be invited to the I Promise School, where I can do a workshop on cardiac arrest, and we could talk about how not to be a victim of police brutality and excessive force and excessive force and force arrest. And Dr. Grant, when I do these workshops, we talked about victim. What does it stand for, right? So it stands for voting. It stands for intervening. It stands for collaboration. And I'm going to stop on the C when I talk about collaboration and communication. Now you're seeing those within our community that are of a certain economic status collaborate and communicate with those that are not of a certain economic status. That has not always happened. There are groups of people within our generation, and I could name some kids presently that think that this is a poor person's issue, or this is a Newark issue, or this is a Bronx issue, or this is a Harlem issue. It's not a middle class suburb issue. And there may be reasons and factors as to why people were stopped, because the way they dress, the way they look, and it doesn't matter how you dress or how you look and what social economic status you are on the ladder. It should not be happening. So hearing LeBron talk about that, he's doing exactly what I ask and advocate those to do, is collaborate and communicate, and he's being a truth teller. He's talking about, hey, look, this is not a movement. This is a way of life. This is who we are, and this is what we have to go through. And we always have to be the educator. We always have to be twice as good, work twice as hard. And 9 times out of 10, we're always going to be victimized. But I don't want to go on that soapbox. So
Mm-hmm.
off of that and stick with the theme of our show, which is bringing the legal and the cultural. And so when we look at Breonna Taylor and we look at what LeBron says and we look at what happened in Minnesota, LeBron talks about videotape. We know a videotape exists when it comes down to George Floyd, and we know in Breonna Taylor's case it doesn't exist. And so now we have what the boyfriend says happened and what the police say has happened. And now this is a perfect example of why a body cam is so important and why there should be a negative inference. And so let me define what a negative inference means. A negative inference is when the court says that we're going to take the opposite of what you say. We're going to take what you think is positive and we're going to take the negative inference from it. So, example, someone goes in the cookie jar, takes out a cookie, they bite it, they got chocolate chip on their lip. The cookie is chocolate chip. The court can say, well, didn't you have a video in the store to see who took the chocolate chip cookie? And the store guy says, yes, I did. Was it working? He says, no, it wasn't. Now, this is very, very out there in a wild example, but it goes to the point. Well, the court can say, well, we're going to take a negative inference. We're not going to assume that he stole that cookie. He could have bought the cookie and opened it up and took one because your camera that's supposed to work on the cookie jar to see who takes the cookies out didn't work. And so, in this case, if you're supposed to have a body cam on and you don't have a body cam on, and you commit the atrocities and the tragic events that took place at the Taylor's home, why should we believe your rendition of the facts when the piece of material, the one thing that we can rely on, that stubborn evidence, not going to change, will always stay the same, is that video you did not have on and you controlled it. So why should we believe you? And so by not believing you, that is the negative inference, taking the opposite of what you say, and we're not going to discuss it. But I will tell you that there are vast differences in the cases, and I understand the trouble to a degree that the prosecutor or the attorney general may have in trying to move forward. I understand it. I don't agree with it. I just understand it because one of the things in Breonna Taylor is that allegedly when the officer first entered, he was shot. And so once an officer is injured, then they have the right, and I'll read exactly from the statute. Protocol allows an officer to use lethal force when threatened or shot at. Threatened alone or shot at. And so if someone's shot at, then return fire. Now, should return fire be 10 rounds? Should it be 10 rounds into the apartment? I would say no. Why do we have a no-knock warrant? So everybody's heard about this term, but what does it really mean? So we can also be educated on why they exist. And this has nothing to do with whether the case is good, bad, or different, or what should happen. This is just informing you as to the terminology so you can speak profoundly about the issue, because there are going to be people that don't look like you, that don't sound like you. They're going to have their argument down pat in public opinion as to why this is not a case of excessive force, racial profiling, and all the other things that we rail against. So no knock warrants. No knock warrants are used usually in drug cases and is usually used to prevent against someone disposing of the drugs while in the home, disposing of the evidence while at the location. So if I don't have to announce that I'm police, then the likelihood I'm going to catch you with the cocaine. I'm going to catch you with whatever drugs out in a place or hiding or in a hiding place. If I say police, that gives you time to flush the drugs. That gives you time to throw the gun out the window. That gives you time to do things, right? And so that's why they exist. The downside of it is not only a Breonna Taylor, but I can tell you a story that I represented a family, a couple, where there was a no-knock warrant. They entered the home. They knew that the father was away. They knew that the mother was at work. So they went in with a no-knock warrant. And guess who were in the living room who could have been victims of excessive force or police brutality? All right, you don't have to guess. I'll give you the answer. A 13-year-old and a 3-year-old.
Wow.
So when the door bursts open, what do you think they do? They either run or either jump or they either scream. And if you had the wrong person at the end, or the wrong person dressed in that police uniform, or the wrong person holding that gun, because when they did the no knock and kicked in the door, they had their guns pointed out, prepared for anything that might be on the other side. These young African American boys might be dead. But so, fortunately, they are alive. Fortunately, no one pulled the trigger. But what is unfortunate is that the law is very ambivalent as to whether or not these young men have a case. Clearly, they've been traumatized. Clearly, their emotional and their psychological makeup is going to be different forever.
Forever.
And clearly, there is information that leads one to believe that the police knew that the parents weren't going to be home. They may not have known that the kids were going to be there, but they knew that the parents weren't going to be there. And so this is another case of a no-knock warrant that can lead to no good and lead to the detriment and the disadvantage and the injury of our people. So that's something that we need to be aware of. And I'm glad that they banned that in Louisville, but that doesn't mean it's banned everywhere else. I don't think there's been federal legislation that made it a federal ban, not that I know of. And we can see the difference in the use of force, one case compared to the other. And so therefore, and let me give you the names: John Mattingly, Brett Hackerson, Miles Cosgrave. These are the gentlemen or the police officers that have been involved. Brett Hackerson and Miles Cosgrave, they're on administrative leave. And John Mattingly, he was fired. Or excuse me, Brett Hackerson was fired. And he's the one that shot the 10 rounds, which was definitely excessive force.
You know, there was a question here. Let me put what Deborah said so you can just comment on that. But no correct communication to the officers that an innocent woman died. Should this also be a point of poor judgment against them? That's what we're battling. And she said, and does the academy train them to confirm before entering by who dispatches the call? So that's interesting because you can speak to that on a no-knock warrant. If they really are supposed to do that, it defeats the purpose.
Well,
right?
Here it is. With a no-knock warrant, that means you had to go to a judge. And in order to get the judge to sign the warrant, you have to set out facts to convince the judge that there's probable cause. And how does that work? Usually there's some type of confidential informant that goes in that does some type of drug trade, or maybe someone's in the apartment and they see drugs, or someone's in the home and they see guns, and then they go back to the police and they say, my name is Royce Russell. I was at this address. I saw drugs. I saw guns, and it's there. The police have to prove to the court that this person does have veracity. That means this person is not a liar. This person knows what they're talking about. And if the judge believes in that, then part of his decision making is that the person is telling the truth. We know that sometimes police force, they have confidential informants. They have informants that come in, and that's what they do. They get paid just to make the transaction. They get paid just to sniff out where the guns are. And let me just put a pin in that and say, we do need that. We want our communities to be safe. We don't want drugs sold in our community. We don't want any guns to be sold in our community. So I understand that. However, that is one of the prongs that the police, FBI, Homeland Security rely on in order to get a judge to grant a search warrant. Once they have the search warrant, then they have a period of time to effectuate that search warrant. It could be a 6 a.m. to 12 p.m. search warrant. It could be a 2 a.m. to 8 a.m. search warrant. But if it's no knock, there has to be a rationale why there is a no knock. And the rationale is that there may be evidence that could be destroyed. And so therefore we have to go unannounced. And does it matter who's dispatching the information? Yes, it does, because if that person is not one that passes the veracity test, then the judge should not sign the warrant.
So that was a good question, and she said thank you for explaining. And Richard said he agrees. This article is pretty extensive, breaking down all of the potential pieces of the case. And I know that we could go on for another whole show, but I wanted you to touch on the FBI investigating civil rights violations.
Right. And so the FBI should be investigating civil rights violations, because what we have here is that if you can't be secured in your own home, where can you be secured? That's the highest level of invasion, right? And to be safe and secured in your home. And if that can't happen, then where can you be safe and where can you be secured? And the FBI should be doing what we call a probative evaluation on how the criminal justice system works when it comes down to no knock warrants. How effective are they? Is evidence really being destroyed? I mean, if you have a no knock warrant, that means you're going into an establishment where there's multiple guns, where there's a lot of drugs. So what is the likelihood of it being able to be flushed down the toilet, right? You see it in these movies, Bad Boys, or whatever movie you might be watching, where they like, get rid of the drugs. The reality is that that's probably impossible to do, because there should be police officers surrounding the premises if it's a house. If it is a project building or a story building, if they throw it out the window, there should be police officers waiting for that. So I think it becomes an issue of like a 9/11 issue, right? How do we want people to be searched before they get on the plane to prevent the plane from blowing up? The answer is yes. There are some people that are inconvenient. Those are people that are not people of color because they're not used to this, but we are, right? But the overwhelming answer was yes. Same thing here. Are we willing to sacrifice drugs being destroyed and versus lives being saved? I say we sacrifice the drugs being destroyed because we want the life saved. So therefore, we need to ban the no knock warrant.
And I think that why this show is so important is because we can break it down and take it piece by piece to really understand what it is that we're watching play out. Because there, for the grace of God, go every one of us. Walking around as a Black and brown person in this country, there's all sorts of potential things that could happen. And I'm sure that George Floyd's family didn't think they would be in the national spotlight. Breonna Taylor's family didn't think they would be in the national spotlight. And here we are with additional cases now coming to the frontline news because of the pressure that is now being applied across the country with what we've unfortunately been suffering from for years. So thank you, Michelle, for that comment. And thank you, Shawnee, for being here. We are glad that Speaking Legally is helping you understand what's going on, because I know a lot of times you can hear these things and it's a little overwhelming. You don't understand. You're just reacting from your own emotional space, but now you have information from legal experts that are explaining what's going on. So we don't do the sidewalk attorney, as I talk about all the time. You can really bring some cited information by Mr. Russell or Mr. Pichardo that can help you just navigate what we're seeing, what we're watching, and be prepared that if you know someone that is in a situation where excessive force has been used or an unlawful stop, you have attorneys that you can call to get the right counsel and who can be working on your behalf to get to some sort of justice. That's what we pray for. And that's what we're praying for with Breonna Taylor as we close out the show today. It is just insane to me. Even Oprah Winfrey put her on the cover of her magazine. So that's using influence. When we talk about cultural, media, and legal, she's using her influence to bring additional pressure and light to the fact that those officers have not been charged.
And let me just reiterate, implementation is so important here, and what goes into it. There is no scientific test that I know of that leads one to become a police officer or not. Everybody is human beings, and they have their own biases and their own prejudice and their own stereotypes that are embedded. And it just amazes me that when you become a police officer, that's the only entity where nobody has that, and nobody will admit that, and nobody will say that they have their own biases and they have their own prejudice, and that since they've been on the job, those biases or prejudice have either disappeared or become more grounded. It's like we'll never admit that. And when we can admit things like that, then I think we have made a step forward. And I know we near the closeout, and I know I put on my prosecutor hat before, but hats change. So now it's the cool out hat, because now it's time to cool out. Hopefully you enjoyed this segment, and hopefully information was important to you and you jotted it down so you can be just as educated as I am on this matter. And if I can do anything to assist you in that way, I will. And I can be reached at 718-785-8890. That's 718-785-8890 at www.roycerussellesquire.com. You can look me up, and you can always purchase Cardiac Arrest, a tactical guide on how to handle unlawful police stops, in Spanish and in English. And I think we may have to come out something in patois in a little bit, because it is pervasive and is everywhere. And once again, LeBron, you're welcome on my show anytime, but I expect the invite at the school in Ohio. And kudos to Cleveland for their just newly elected, I believe newly elected, was it Corey Rush is her name? A young woman that ran for office last year or a couple of years ago, did not make it, but then made it. And she is described as a progressive African-American standing in the forefront of civil rights movements. So kudos to that. And I expect my invitation sometime soon. All right.
I think everyone's going to get the word out to LeBron. It would be great for you to be at the school doing a workshop on cardiac arrest. That's what we need in our community, is information. You need to read something before you what?
Need something.
All right, everyone. Thank you for being here. And we look forward to having you join us next week, same time, 4 p.m. Eastern, Speaking Legally, where the legal meets the cultural. On behalf of Edward Pichardo and Royce Russell Esquire and myself, Dr. Stacey N.C. Grant, thanks for tuning in. Share the show with someone and come back next week.